expressed by the court for hearing the interveners. Now, that writ petition is 4338 of 2022. My lord, that petition which we have filed, my lord, seeing what is happening, my lord, after March of filing of the petition.
It is here. It is here. We can hear you.
Yes, my lord.
Let your turn come.
Yes.
Yes, start with the arguments.
May it please, my lords. I beg to
Yes, you are for respondent number 8.
respondent number 8, my lords, in 3146, my lords. I'm obliged to my lords for the indulgence, my lords, for a few minutes to make some submissions.
Only request is that be brief as much as possible.
Absolutely, my lords, absolutely. By way of
we are running out of time.
I fully understand, my lords. I fully understand. I'm obliged to my lords.
We cannot accommodate every day.
I follow, my lords. I follow. Only to supplement, my lords. In fact, I will not even take the 15 minutes which was sought from my lords. Only a few minutes I will take, my lords.
Yes.
There are two perspectives I wanted to place for my lord's kind consideration, my lords, in the entire matter. Wide-ranging submissions have been made from either side, my lords.
Yes.
The regulation which is now sought to be challenged, my lords, in my respectful submission, would have to be considered from the point of view of, my lords, the objective it seeks to, my lords, achieve. The objective in my respectful submission, my lords, is bringing about, my lords, uniformity in, my lords, the treatment of students in an educational institution. Now that, my lords, is an objective which is in furtherance of, my lords, the act itself, the Education Act itself, and, my lords, to ensure non-discriminatory, my lords, treatment of students in an educational institution. We are dealing with, my lords, activity which is essentially, my lords, in a secular space in that sense. The moment, my lords, a student comes to an educational institution and partakes in, my lords, the imparting of education, secular education, any, my lords, regulation or stipulation brought in, my lords, to bring about non-discriminatory treatment of students would have to be viewed in the light of that objective and cannot be sought to be questioned, my lords, on the premise of Article 25. That's my submission for my lord's kind consideration, my lords. Of course, the concept of, my lords, a uniform itself in an educational institution is for the laudable purpose, my lords, of ensuring that whatever be, my lords, the background of the students, whatever their background they come from, whether they are penurious, whether they are from an affluent background, what is their caste, what is their creed, what is their color, what their religion is all sought to be completely obliterated. In that view of the matter, my lords, my respectful submission is the regulation that is brought in would have to be tested on the anvil of the objective of non-discriminatory treatment of students pursuing, my lords, education, secular education in a secular space. This is one perspective I wanted to place for my lords kind consideration.
Yes.
The second aspect, my lords, that I wanted to highlight is, my lords, the nature of jurisdiction, my lords, that is exercised by constitutional courts in such matters. My lords, notice that the grievance of the petitioners is premised, my lords, mainly on the ground that, my lords, the wearing of the attire in question is part of essential religious practice and therefore protected by Article 25. Now, my lords, the nature of jurisdiction that is exercised by a constitutional court when such a claim is made is not really part of, my lords, any ecclesiastical jurisdiction. That's an important facet, my lords, which will have to be borne in mind in my respectful submission. It is really as a matter of constitutional necessity that the courts get into it. And therefore, there are, my lords, limitations to what kind of determination can be done. Now, this aspect, my lords, has been taken note of by the Honorable Supreme Court in one decision. That decision, my lords, is Adi Saiva Shivacharya versus State of Tamil Nadu. That's reported, my lords, in 2016. Volume 2 Supreme Court cases, page 725, my lords. My colleagues, my lords, who are physically present in court, I understand, would be carrying a copy and perhaps provided for my lords ease of reference, my lords. Just one or two portions there, very, very small portions.
You don't have any copy. You are trying to obtain. Unless I obtain that.
May I give, my lords, the para reference and read them, my lords, so that the judgment can be circulated to my lords, my lords?
We will consider it.
Yes.
You proceed further.
Yes, my lords.
Give the paragraph.
Yes,
Relevant.
paragraph number 38, my lords.
38.
Yes, I'll just read one or two portions in that, and then from 43, I'm done with that reference, my lords. Paragraph 38. May I place that, my lords?
What has been said in that? What is the ratio laid down?
The principle that is noted by the court is this, my lords, that the ecclesiastical jurisprudence in India is really not something which is conferred on courts, but because there is a claim made, my lords, under Article 25, the constitutional courts, as a matter of necessity, are going into such questions. And it's not easy, it's not an easy question to determine.